Okay, fine. Okay, everyone, welcome to the Thursday, October 2nd, 2025 meeting of the Legislative Review Committee. We're starting here at 1:11, and we're going to start with approval of the minutes. If we have a motion.
I don't even have a copy.
All in favor?
Hold on, it's for the. Aye.
Aye. Aye. So the minutes are approved. And we will go into public input. We don't have any public here. Oh, David, do you want to say anything?
Well, sure, thank you for entertaining this idea of, maybe, creating an ordinance for downtown. I think what we're looking for is kind of reduce the anything goes climate regarding noise for downtown. I've even talked to rank and file officers. They say, well, with the, the catch all any commercial activity, and sort of, gives the impression that anything goes downtown. So we're just looking for maybe some sanity.
Thank you. Very clearly stated. All right, and I'm going to turn it over to the Sarah from the manager's office here to introduce this topic for discussion today.
Yeah, so thank you. So I'm pitch hitting for Ilka McConnell, our interim assistant manager who's on vacation. So I appreciate your patience with me. As you know, we have been discussing the noise ordinance here in committee. And this charge had originally by mayor both focused on potentially looking at updates to help extend it into the agricultural residential zone, but also looking at commercial downtown district relative to amplified noise. So we covered and we basically have split this topic because in our last meeting, y'all voted out some ordinance changes that are currently on the agenda cycle. So for any members of the public that are watching, we currently have a topic that will be voted on up for consideration next Tuesday related to that agricultural residential zone portion of the ordinance. So now that we have split that topic, we are still here in committee talking about the commercial downtown. So that'll be the focus of all of our future conversations here. And so in our last meeting, we kind of started hearing about what are some of those challenges that we're hearing, both from David Lynn with our Athens Downtown Development Authority, but what are those other problems that we're seeing? So in preparation for this meeting, our staff has been working hard to try to pull together both some data as well as some examples and research from other peer communities. So you're going to hear from Harrison Daniel, who is our deputy chief with the police department related to our noise complaints in downtown district. He's done some additional look at that to make sure that it's up-to-date information for y'all. And then you'll also get to hear from our attorney's office on some examples of best practices. And we are going to also share some examples of other jurisdictions that do look at the decibel meters, since that also came up in the last meeting. So first up, I'm going to turn it over to Deputy Chief Harrison Daniel. He'll walk us through our updated noise complaint data.
All right, thank you. Do y'all have a display for the screen or just
Yes.
handouts for everybody?
We have both.
Okay, so as the committee requested, we provided some data. This is currently 2025 year-to-date data for noise complaints specifically in the downtown area. So the map that you see at the top of this printout is the general, that's the radius that we were looking at when we considered the downtown area for this data set. And so overall, what you can see is the average time that the noise complaints are coming in is about 7:29 p.m. But the most common range is between 8 p.m. and 12 a.m. On a 24-hour cycle. The average distance of the complaints from the source when we were able to determine that is about 0.69 miles, 0.7 miles, so a little over half a mile away. Shortest distance measured was 0 miles because it was right in the same location. But there was at least one instance where the complaint came from up to potentially 7 miles away from the source, based on what we've got. As you move further down the page, you'll see the disposition. So of the complaints in the downtown area over that time period, these are the disposition breakdowns. And so you can see, how those ended up, how those calls ended. And then flip over, there's just a visual display of that on a pie chart. So you'll see the most common 33% of noise complaints ended as a verbal warning. The next most common was, that they were unfounded once the officer actually looked at them. Moving down to the next chart, you'll see the top 10 as was asked for in the downtown district for complaints. 247 Pulaski being the number one with 9 complaints here today. Then moving down to 149 Florida Avenue. You'll see that address listed more than once between the number 2 position and the 4, because those are apartments and they use the same street address. And so you're seeing those listed more than once, and that may happen on occasion when we're dealing with apartment complexes. So that's the top 10 breakdown. And that's the data that, hopefully that answers the questions y'all asked for. And if you have any other questions on this or anything else, I'm happy to answer those.
When you looked at the pie chart, you said it was 33% warnings, right? Yeah,
Yes, ma'am.
and then you said, unfounded was
21%.
So so really, those are not the same numbers, are they? I mean, it's not like we got a warning, but yet it wasn't unfounded.
Right, so if an officer issues a warning, that means they felt that it was a violation, and they issued a verbal warning as opposed to issuing a citation at that moment.
But in that 33, that's not, 21 is not coming out of that 33. Those are 2 separate things.
That's correct, yes.
Okay.
Can you help us clarify what's a warning versus a verbal warning?
So, verbal warning is, I mean, they're issuing a verbal warning. A warning, as you see here, that'd be where they actually wrote the warning out on a summons. So they can fill out an actual citation, but then instead of providing a court date, they sketch on there that it's a warning instead. So the court knows it's just a warning, but it's written out and documented and sent to the court.
And does that require come and talk to the judge?
No, ma'am, it does not.
But it's a leave behind with a verbal or instead of a verbal warning? You know what I mean? Is it like you leave the citation? You have to still give that to somebody. Right?
Yes, so that would be issued to a person,
Okay.
The written citation, correct.
And what would be the reason for doing a written warning versus this verbal warning? What's I mean, is there any standard procedure on that, or is it?
So in those cases, the officers don't have a set rule of if A, then B necessarily. They're given the discretion to make that decision based on whatever circumstances are confronting them at the moment.
And does a written warning mean something more in terms of subsequent written warnings? Or like, does that lead to something that you wouldn't have if you just had a verbal warning?
No, essentially the same thing. It's a warning, just one is written down on paper and that paper ends up going to the court versus the other is just a discussion between the officer and the individual.
Which is lost, so that if you did have a citation, there would be in the citation, if it did go to court, a judge might get the written warning might be part of the case, that wouldn't it be there?
It could be, it could also be, correct me if I'm wrong, it could also be presented, not just the written warnings, but, if the prosecuting attorney, if it went this far, they typically don't, but if it went to the point where somebody asked for a bench trial for a noise complaint, the prosecutor could introduce additional evidence, potentially of how many calls we received out there on a particular night, regardless of whether we issued a written warning or a verbal warning. And so it could be used in the prosecution of the case if it went that far.
So the nuances of this, some of this is just the individual officer at the scene determining the difference between a non-applicable and a unfounded. I mean, that's just sort of how it's logged.
So the NA is actually where you may have, so NA could be where this started out as a noise complaint, but then it turned into something else. And so when our dispatchers have to key it into the system, they would have to change the call type. And so it may have started as a noise complaint. It turned into something else. The disposition doesn't relate to the noise itself anymore necessarily. It relates to the more serious issue that was discovered perhaps. So it may be because of that, or the call was canceled for some reason. And so that's what NA would be. It's generally gonna be like a duplicate because we ended up doing multiple things.
But you, that could have started with, but to have been in here, at least started as a noise complaint, is what you're saying.
I would think so, yes.
So, first of all, let me clarify myself. When you gave those figures of the 33 and the 20, you were just showing the highest and the next highest of the complaints. I read that wrong when I asked you that question earlier.
Right, so those are just the
You just picked the high, you mentioned the
highest
highest. Okay,
disposition.
that's so,
Right.
excuse my question,
Yeah.
that question earlier. I'm pretty dumb now that I think about it. With the, verbal warning, is that in the system? I mean, can you come and give me a verbal warning 10 times?
You could.
It doesn't show up though.
So if it's a separate call, then it would be a new call with a new disposition. So it would show up a second time. So let's say, for example, we got called to your house for a noise complaint. And we came out, talked to you and gave you a verbal warning, and a few hours later, we got another call and another officer came out and spoke to you again. That'd be two separate entries. And so we would count that twice, even though it's at the same address, and then each one would have its own unique disposition.
Any other questions related to this?
Yeah.
The data? So the one thing I wanted to point out on this, and Harrison kind of touched on this, is that when we were looking at the data, particularly of the complaints for the downtown areas, as he mentioned, most of these complaints really were involving events going on either at fraternity houses or noise from apartment complexes. So why is that important to this conversation? Because of course, we're kind of looking at it from a charge of how do we address amplified noise? And I just wanted to note that in terms of the data that we're seeing from complaints, we're not seeing as much reported, at least in complaints, for commercial entities. So as we kind of move forward and we're looking at what problem are we trying to solve here, I do want to point that out. Now, that's not to say that there's not a problem downtown with amplified noise. I mean, I can tell you from firsthand experience, I can be in my office and I can hear amplified noise from downtown on a Thursday night, even when I'm here. I'm sure the attorney's office can vouch for that as well. So we know it's happening, but I just wanted to point out while we're here and we're talking about the data, that we're not necessarily seeing it from a complaint reporting standpoint.
Well, I think that people have, stopped complaining because it doesn't get any
Right.
further due to the
I'm sure
limitations
that's true.
in our current, which is why we're here today, to see, how we can rein it in and have it, feasible,
Right.
fair and
right.
feasible to,
Yeah.
how was that, add some sanity into?
Yeah, exactly. But if there's something that we need to also address related to the noise that we are getting complaints on, I wanted to bring that.
Right.
Okay, well, next up, we're gonna hear from our attorney's office. I'm gonna turn it over to our deputy chief attorney, Austin Jackson. He's gonna kind of start to introduce some of the best practices and examples from other jurisdictions.
Thank you, Sarah, and I'm gonna sound a little bit like a broken record. You probably remember this from last meeting, but I would be remiss if I didn't remind everybody to kind of orient our discussions, to remind you that what we're talking about here is First Amendment constitutionally protected speech. As I noted last time, the Athens-Clarke County noise ordinance has actually gone up on appeal before the Georgia Supreme Court, and the Supreme Court did hold or recognize that, we are talking about First Amendment speech, even though we're talking about amplified sound, because music and things of that nature do qualify for First Amendment protection. And the second thing being that Athens-Clarke County's noise ordinance, as it is currently written, does constitute a reasonable, content-neutral time, place, and manner restriction. And so when we're thinking about changes or modifications to these noise regulations, that's something we need to be keeping in the back of our mind, because ultimately any change that this body recommends is going to have to pass not only the United States First Amendment test, but the Georgia State Constitution First Amendment test.
Austin, a quick question on that,
Yes.
on the free speech thing. So you're saying that if I was sort of saying music is, if I'm the producer of the music, if it's me singing, that's free speech, but you're implying that even if I'm playing someone else's music, that counts as free speech.
Absolutely, and I'm happy just to read from the actual opinion from 2011 from the Supreme Court. And it says that, the parties recognize that, I will say that at that time, subsection C2A, the part about amplified noise was being challenged. And the court said that mechanical devices that target, so the mechanical devices that section targets, such as televisions, stereos, radios, and musical instruments, produce not just random noise, but music and words that qualify for protection as speech. And therefore, anything that we do is going to have to be able to pass not just the federal constitution's test, but the state constitution's test. And the state test is a little bit more restrictive. That's just sort of the reality of the landscape we find ourselves in. And so I typically try to focus these types of analysis on passing it under the state test, because if you pass under the state test, you're more likely going to pass muster under the federal test. And so just remember, any regulation that this body recommends must be content neutral, meaning that you do not focus on the content of what is being expressed. And you have to have there are three parts to the test. Okay, the regulation has to be the least restrictive means of achieving the government's significant interest in protecting its citizens from unwanted noise. And that regulation must leave open ample alternatives for expression. So 3 points. You got to have a significant government interest, which we do, because the Supreme Court talked about that in the 2011 case. It recognized that local governments do have a significant interest in protecting the citizens from unwanted noise that interferes with their public, not their public, but like their peace of mind, repose, welfare, things of that nature. But anything that this government does has to be the least restrictive means of achieving that interest that also leaves open ample alternatives for expression. And I think at this point, unless Courtney Davis has anything else to add to that, I'll turn it over to you to talk
Just
about.
one more point about, so that case, the 2011 case, and it's our ordinance as it currently is. Ironically brought by a student at the time who's now an attorney, so whatever, guess he learned. But in addition to the holdings that Austin's speaking to, our ordinance was specifically found to be upheld because it was deliberately drawn, our rules were deliberately drawn in response to specific concerns, right? So that's sort of to what Sarah's point, that there were specific concerns brought up, and then the ordinances were narrowly tailored enough and deemed to be the least restrictive means to achieve that. But it's important to note that the deliberate nature of those ordinances was important, at least to that.
Absolutely.
So that applies to like what we just did with the,
That's exactly what I was going to say.
Y'all did a perfect job.
right.
With the fairgrounds, like, the police department provided some data based on the number of complaints, based on the distance. And so the recommendation that this body passed to the full mayor commission was based on that rational data. And so I do feel that text amendment is defensible, because if we're challenged, we can point to data.
Right, so right now, so we have David and we have what Allison is sharing, we don't have data from that's officially complaints to the police department or code enforcement.
Yeah, the most defensible ordinance would have like strong data behind it to suggest that a change was necessary. Right. And it's not that it's not out there, we just don't have it yet. Yeah, we haven't asked the right questions, or we haven't asked the right people, or something like that.
So it's just something to think about as we move forward.
Right,
It's like
exactly.
there may be additional data that we need to collect to try to get that level of concern that we obviously are hearing. How do we collect that in a way that we can demonstrate that level?
Do you have an answer on how to collect that?
So that's a great question. Part of it is going to be up to, Harrison.
The only thing I was gonna add is, when we're talking specific locations, again, this was just the top 10, which is what we were asked to produce. That doesn't mean that there aren't other locations that we haven't received noise complaints about. They just weren't in the top 10 list.
So is it something that we can look at further to see if there is any commercial amplification?
Yes, we can do that. We can identify of, all the noise complaints, we can distinguish
Perfect.
how many raw number and what percentage of those are commercial entities in the downtown.
Right,
district.
because right now, we're already at 2, that's pretty low, so putting it, categorizing like commercial. would be
Right, and what
good.
you could see, and I don't know, is, while it may not make the top 10 list, you may have, 50 noise complaints about a commercial entity, but each one, it was one complaint about 50 different entities. That makes sense. So they're not gonna make this top 10 list. So, does that make sense?
Yeah.
So if you have, 100 noise complaints and your top 10 list are not commercial, that's based on how many complaints came in for each specific location.
Mhm.
But you could still look at the data and potentially have 50% of your noise complaints are driven by commercial entities.
Oh, right, yeah,
One location.
One at a
right,
time.
right.
That's possible.
I'm gonna suggest that a lot of the unfounded calls are calls coming from downtown. As a police officer, I come to that location, along the park, et cetera,
Yeah,
this doesn't apply in the ordinance, this compliance on.
That's-
and that is correct, yeah.
Yeah, and so it goes under the unfounded category, but I could also say that we could open up a survey or whatever you want, or have commissioners or others in the community who received the complaints, if we needed
Yeah.
the data for the emails and the complaints. But again, I know that a lot of the people that I've had to explain why it can't be enforced, they haven't quit complaining, they just quit the email. Or it's dimmed it down a little bit. So I think that, as we learn, I think what we can see with some of these other communities, if they are doing it, we might not have to have the data if some of these other solutions can help us.
Well, one takeaway we'll have, and I'm just wrote it down, is we'll ask Deputy Chief Daniel to look back at the data, see if there are, what are the number of complaints generally for commercial fees within the downtown area.
And these are also, in this little chart here with the top 10, these are not, are these number of, lack of a better word, does this exclude unfounded complaints? Like, could 247 Pulaski have been, half of them could have been, would that have gone in there, or did you take those out of the chart? They're just any complaint?
We did not. It's just, that number means that a complaint happened regardless of this decision.
Okay, got it. Thank you.
Good to know. Okay, thank you. We'll start, go through your mini handouts. Okay, so just to frame the conversation, this is your, noise ordinance. All right, so everybody should have the Athens one as well, just so you can refer back to it. And then let me just kind of go through and talk about what the general categories of these. So you'll have two, one that says Sandy Springs on the top, and then one that has no county on the top. It looks like this. It's Smyrna, okay? These two, Chief Deputy Daniel pulled actually, because they speak to the decibel kind of issue. And then we're not, if it's okay, we'll put those aside for right now. I'll get back to that. So everybody put aside Sandy Springs and Smyrna. And then what you'll be left with are three others. So, a portion of Atlanta's, Savannah's, and Stonecrest, actually. And the reason, and so Caitlin is our intern this semester. She's doing a fantastic job. And she helped me to identify ones from around the state. And she specifically looked at, some of the other consolidated governments. Some of them that might have Statesboro, places that have sort of, student populations and things like that. And so we kind of scrubbed those a little bit, and I've come up with three representative ones that basically have different things in them than your current ordinance. I will say the current Athens ordinance is duplicated in many communities all over the state, and I have to believe it's because of that 2011 Supreme Court case. Okay, so I mean, obviously, right? There was a model out there that was tested. It was an easy cut and paste for communities. So ours is duplicated all over the state. But here are some variations to that, may get to, I guess what I don't know is sort of what you guys are going to deem necessary from an enforcement standpoint in terms of what's lacking in our ordinance, right? So that is making cases hard to
to make and citations hard to issue. Obviously, there's been discussion about it being, and mostly because it's the commercial entity portion. So you guys know a lot about this from our last discussions. Commercial entities, are permitted to make noise within the regular course of their commercial activities with some restrictions. And the current restriction is that emanating into single family housing zones, right? And then you're about to vote on into AR zones. There are, if you look at Atlanta, just as an example, just the one page, and what I've done is I've highlighted, they have a bit more of an expansive, you see this, they expand into single family, two family, multifamily, and commercial entities near mixed use zoning districts. Okay, so they have sort of an expansive field of what's the less permissible or unpermissible in terms of where the noise may emanate into. So that's kind of one family, and Atlanta's just an example. I'm sure there's others who do the same, but that's one family of a difference, right, that you could consider. And I'll just walk through the rest of them just to show you different families of families of differences as well. Okay, if you look at Savannah, right, so it's the colorful one. I've actually kind of gone through and highlighted several areas that are different. Savannah is very different than ours. A couple areas, I mean, they do use decibels. We'll get to that in a minute. This is a decibel community. Savannah is similar to a lot of other communities that also prohibit noise, even from commercial entities, from coming into noise sensitive areas. These are areas in some municipalities define that better than others, but typically those are areas with churches, nursing homes, hospitals, things like that. Okay. There's usually a posting requirement too within those areas. But if you'll skip over to 92036 within that, that's the portion that's most heavily highlighted. Yeah. This section, let me say this let me preface this as saying, I'm not 100%, we haven't vetted, it feels uncomfortable, okay? I'm not sure that we wouldn't advise right this second for you guys to adopt this. We really need to take a look at it, but I'm showing you what an example is. And this is in Savannah and Statesboro. But if you look at this first part, the first part that's highlighted about noise disturbances that cross real property boundaries or go into these noise sensitive areas are prohibited, right? And that's when persons are operating amplified noise that go into those areas. And then there's this provision that says, however, bars, taverns, lounges, nightclubs, dance halls, game rooms, it's kind of some old language. Yeah. And similar activities which produce a noise that is plainly audible beyond the premises shall be deemed a noise ordinance violation. So that's one that's pretty targeted at sort of downtown type establishments or bars. And also, you'll see that's plainly audible beyond the premises. So it's a pretty restrictive standard, right? There's not the feet that we talk about, the decibels, things like that. Then there's some additional things down there for getting permits or like some exclusions for sound equipment that's permitted for things like street festivals, parades, things like that. But I think that first highlighted portion, the kind of more stringent rules for bars and dance halls might be of interest. Yeah.
So do you have an idea how long this has been in play to know whether it's been, how well it's going?
Well, there's a reference down, I don't know if it's updated here, but there's a reference down there indicating that it came from the 70s, and certainly the language was just came from the 70s. Game rooms and dance halls. And our previous, and prior to this 2011, I mean, ours had been that old up until that point.
I was just asking David if he had anything to share on this, because he also shared this panel.
Okay.
As well. Was there anything you wanted to point out related to that section before we move on?
No, I just was pointing that this was an ordinance in Georgia, which seemed to be important. And, it was a different approach that specifically dealt with, some of our problematic users in a specific way.
Yeah, it was definitely the most sort of specific response. And again, it's duplicated in Statesboro. And again, we're not presenting it to you as like, this is a great idea, let's do that. I'm just presenting it to you as something other communities would do. We would want the opportunity, obviously, to vet it and also probably talk to those communities as well to talk about enforcement and any sort of strategies they have.
Right, and I appreciate that you also have a town and gown environment here for Statesboro as an example, because if our number one is a Greek
Right.
oriented, and housing is top, it's relevant. And so I think that that's a great idea for maybe the next meeting, is for us to learn what additional knowledge can be gained from this in a, modern terminology, but, taverns, but, and then the,
Similar approach, if I could add.
Yeah.
It's not in Georgia, it's the city of Asheville, which just has a similar community downtown spirit than we do. And theirs has been even strengthened since 2021. I know that's not Georgia, but, it's not like it's in some radical state or.
Yeah. And then
Take a look at that.
yeah, we will for sure. And I will remind you about Austin's point, Georgia, we're a land of anomalies. And one of them is that we do have a more stringent constitutional test for,
Understood.
yeah.
right, and I also liked, Lauren, well, the noise sensitive activities in areas, I think that some of us would consider residential, that, not just nursing
I
home.
looked at it, it was churches, nursing homes, hospitals. I mean, arguably, the hospital's very close to like Authentic and that area, which I know generates a good deal, number of them.
And it doesn't specify which kind of schools either.
No,
Yeah.
there were some vagaries in these that I would want.
Yeah.
We would advise y'all to tighten that
Mhm.
for sure.
And then on the most colorful page, the sound equipment permitted, without having read it in depth, like we will by the next meeting, is just understanding, like, I would hope that we could have it for when you have a special event permit, you're also permitted to do different than without a permit. Such as the examples of who get, instead of it being megaphone, back and forth, if you have a permit, you're running a race, you're the only one that's gonna be able to say, go, versus competing.
Okay, we'll have to look at that. That's not really contemplated in this. Yes.
It's not,
Well,
it's like recreational athletic, like if you have a permit, you have a permit to be, just like Athens would have a permit to have amplified where it's typically not. Is I think important for us, and it'd be criteria.
yeah, okay, so then a linking to permitting, yeah, because this even talks about lawn and pool parties, street
Yeah.
dances.
Yeah.
This is
Right.
hysterically.
Yeah.
Right, it also, I mean, this sound equipment, I mean, unless I'm reading it wrong, no person shall use operated cause to be used, record player, tape decks, loudspeaker, for reproducing sounds upon the streets or in any building, public source, reducing noise to, I mean, that's pretty, or the following activities were authorized, but, so you could have a
Yeah.
permit and here, but that, going back to Stephanie's thing about people playing music on the street, that would disallow it, or the
Well,
public.
it's the amplified version of it. We're not disallowing a performer. But if
Well, it
we
is,
have
I
a
mean, the
new,
way this is saying, but I'm saying this thing is saying, you know, anyone having a radio, record player, tape recorder, loudspeaker, that's not allowed unless it's permitted in this is what this is saying.
and I think
Yeah.
that that's something for us to understand and know if we can go that route, because have lots of areas, and we're about to have a new park and a new College Square that we would not want dueling amplified music happening for people who aren't there for that reason.
Right, when there's something, so the permitting process would be something we could look at. We have definitely, I mean, earlier this year, like in April, we issued a memo to you all about just sort of a blanket ban on amplified noise, and you can go back and look at it
Yeah.
but we would strongly advise against a blanket ban on noise. Just
Permitted. Yeah.
And then the final one that I pulled, just with some differences as well, was from Stonecrest, which, actually Oka turned me on to because she saw them present at some sort of meeting where they were talking about how to incorporate music businesses and things like that. And you'll see this, the highlighted section, I'm losing track of page 3. Right, exactly. But it addresses commercial, industrial areas and mixed-use development areas in a different way than they do as well. And it also incorporates a decibel.
Right. And so when they say within the city, that's, you know, a geographical area.
Yeah,
Would
just
we be
within there.
able to, would we be able to do within downtown business district? So, or just not answering now, but understanding with your research, can we have geographical areas, like they're saying the city, could we have also a defined geographical area that we're discussing? It's either a yes, you can't, if, just understanding if we can do that.
I think, yeah, and we'll look into it.
Yeah.
And I mean, I think just thinking about that initially, there'd have to be a substantial government interest in having a bar and downtown have to be quieter than a bar out on 78. Do you know what I mean? So we'd have to really think through what the government interest would be in that.
So what you're saying is, let's go big.
I did not say it's
I'm just saying,
I like
because-
small.
But just understanding how that would be, because I do understand that there are other areas. I'm not trying to ignore them. I want to be comprehensive, but also what is defendable.
Absolutely. So those are sort of some of those are pretty good representatives throughout the state of different ways that commercial noise is dealt with in our current ordinance.
This is like, this one in Stonecrest, I mean, I'm looking at the exclusions here, but I mean, this like, you gotta stop at any sound from 11 PM to 7 AM. So we just, in terms of what we just made with the one that's about to be approved, this one is like, that one allows sound, but
It's within
just
a
at
smaller
very,
range.
this one like just makes it, like, you can't do it. You gotta stop that sound, right, at 11 PM, if I'm understanding this correctly?
That is plainly audible
Yeah.
within the interior of a.
Single family detached field.
This is, a lot of them use this, right? Within, if somebody can hear it with their windows closed,
Mhm.
then that's sort of the plainly audible standard that they employ.
So from an enforcement standpoint, and I probably would lean on y'all, if we were to do something like that, would we have to actually enter the residence in order to ensure that it was plainly audible? Because I know that was a point that got brought up related to some of the complaints we've heard from multifamily residences, is that oftentimes you'll hear a neighbor, and they'll complain, but they don't want the officer necessarily entering their apartment to hear that between walls. So I just wanted to bring up that point and make sure that that was.
Yeah, it's an excellent point. Yeah, all of these have, really a lot of enforcement.
Some challenges.
Yeah, challenges we'd have to think through. But those are some sort of representative, just because when we were coming into the conversation today, we weren't sure, what the policy ideas would be. So we kind of came with some differences there. And then the others, if you, at the time that we move on to talking about decibels, the other ordinances, a lot of communities do use decibel as the sort of the enforcement part of it. And these are just two of the many examples that Harrison and pulled for us, but I just brought two.
Okay. Well, then with that, if the committee is okay, we'll go on and move to discussion related decibels. So Deputy Chief Daniel, I know you shared the same. I'm sorry.
No, I just looking at this. Under our ordinance, it's, C number 1, and it says restrictions of 300 feet. Is that 300 feet, and less? I'm remembering a situation that I had, and
If you can hear it from 300 feet away from the property limit of where the source, where the noise is emanating. Right?
That's right.
That's
yeah,
how you
yeah.
would say it.
So a distance of 300 feet or more from the building.
So if you
So-
hear it at 301, if you
Yeah.
can hear it at 301 feet,
Mhm.
it's a problem. If you hear it at 299, but not at 301, it's
Maybe,
not an exact science,
but
but that's what this
I'm
says.
just
Yes,
thinking
ma'am.
about a situation I had when Chief Sproul was here. And I think it was the feet thing.
Yes, yeah.
Just under.
Yes, ma'am.
Okay, well, Deputy Chief Daniel, I know you did a little bit of looking into decibel meters in some other jurisdictions that do use them. You want to kind of talk us through what you have heard and what you found?
Absolutely. So specifically, the ordinance in Sandy Springs, I believe, was brought up last meeting because they had just gone back to a decibel system. I pulled that ordinance for everybody to look at. I think you should have a copy if you want to look at it. I also reached out to a captain over the department I have a contact with. Just generally asked them how they enforce it, how does it work? So he said they don't get a lot of noise complaints over there specifically. And he was only aware of about 7 or less that had actually gone to court in any way on noise complaints. He said in their jurisdiction, they really haven't had a problem with the decibel thing or using that, but they've never really had anybody challenge it at any significant level either at this point. They use some basic decibel meters and their policies require them to be certified and calibrated on, I think it's an annual basis over there by the county ordinance or the city ordinance for them. So that's the feedback I got on that. I did do a little looking into different types of decibel meters out there. They range from very cheap being, maybe $100 up to a little more expensive models in about the $400 or $500 or $600 range. There's certain standards that have to be met with those. And there's different levels or different standards of type 1 and a type 2. And that basically gives you a determination on what, how sensitive or how well calibrated the decibel meter is. So you could run into some obstacles with that depending on, for example, if you have a type 2 and you have a smart attorney who wants to defend this and they come in and say, well, what's the difference between a 1 and a 2? And a type 1 is a better decibel reader and you're using a type 2, then you could have a problem with that. The other thing is they sell them often in packages where you have the decibel reader and then you have the calibration tool that goes with it. I did find some information that talked about how not only do you have to check the calibration on the meter with the tool, then you got to reassure that the tool is accurately checking the meter. And so you start to get a little bit down a rabbit hole if you really want to push the science of it to make sure that what you're reading is off the device is accurate. A couple other points in the ordinances, similar to our noise ordinance with plainly audible, you still have things you have to decide on, such as what distance do the decibels have to be measured from? So for example, do I have to be standing 10 feet, 20 feet, or 50 feet when I take the decibel reading of the noise source? And so there's decision points there that would have to be decided. So you still run into a few other issues there as well. That answers most of the questions.
Okay. And is there anything from the attorney's office standpoint related to the decibel component of these ordinances that y'all want to touch on?
No, except that if it's a conversation that y'all wanted to continue with decibels, I would encourage you to bring the solicitor's office into the conversation. They prosecute the cases, so they may have really good feedback about that.
Could we bring him to the next meeting?
The only other thing I would
All the
add
reading material.
I mean, cut you off, sorry.
Sorry.
The only other thing I would add is that prior, I think yesterday I sent out some previous memos that our office wrote. One of those does touch on the sort of legal issues with decibel meters. We would stand on that legal advice in that confidential memo.
More
I know
reading,
that's already been kind of.
more reading. I
Send it.
got it. I got it. That's fine. That's fine. We've got a lot going on. We'll get to it.
Okay. So y'all heard a lot from us. So as we start to look at potential actions that we may take and some additional information, obviously there's a lot of other information we need to bring forward. But based on what y'all have heard today, I guess I want to kind of touch base with the committee as well to see what is of interest in learning more for us to kind of learn more about. Are we more interested in looking at those noise, what do we call them? We call them noise sensitive areas and the noise emanating from bars that are plainly audible beyond the premises. If so, we need to do a little bit more research on our end, both from the attorney's office standpoint and investigating and vetting that a little bit further. And of course, I would ask our enforcement folks to look at it from, talk to their peers in the communities to figure out what that looks like. Is that of interest to y'all? What have y'all heard that you want to know more about, that you, well,
What code enforcement's it? Angle.
Yeah.
What do y'all have?
do y'all have any thoughts?
Yeah.
No, I mean, we normally just address it during the day and most of this is occurring at night, so mostly just listen to that.
I want to know what the problem is we're trying to solve and make sure that are we trying to, that the only thing I remember hearing is that people at the bar, what's in the bar?
Well, I think we're trying to solve two issues.
Yeah.
I think there's an immediate problem with bad neighbors, loving neighbors. And this, in a specific sense, the complaint I brought forward was from Clarke, they felt losing business because of the noise emanating from Paloma Park at completely unreasonable times, like in the morning, Sunday brunch, that kind of thing. And even if they approach their neighbor in a business-like way, the neighbor typically would just turn the sound.
Right.
I think the second issue is more of a policy issue. I'll put on my economic development hat. The biggest criticism we get for downtown is, oh, it's just for students. There's nothing down there, it's just for students. And we have probably 10,000 people living downtown, which is larger than a lot of cities in Georgia. But if we ever want to attract a non-student residential population downtown, which is important to us, then we have to create an atmosphere that you're not being woken up at 1 o'clock in the morning. So I think those are the problems that we're looking at.
Yeah, I could see that. I was, at our retreat, and there was music
In the courtyard.
in the courtyard.
Yes.
We're going boom, 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 and there are people living right on the,
Yeah.
like, the hotel was one side and then there were residential, and I feel like I'd be having a problem if that was like,
But they did quit at 10.
they do quit it.
I hear. I mean, go to school.
Yes.
Somebody told me. But I wanted to know the feedback on the Atlanta code that's adding, because what's highlighted is of interest here to me, the commercial entities near single family is ours, but yet they have 2-family residential, multifamily. So can we have a little chat about this handout?
Yeah, of course.
Just to read it and see, I mean, does that seem defensible the way they have categorized things? And if we were to change it, are we able to change it without it? Are we able to include, broaden ours?
Yeah,
And would that address the kind of,
That's my question.
Yeah.
Would it make a difference? I mean, and that's an enforcement question. Is the reason that we're not able to issue citations is because the noise is emanating into a mixed use zoning, area? So that's what I would want to know. In terms of, and the Atlanta one is structured very similar to ours in terms of, plainly audible and things like that. So it's not a huge departure from
Right.
what we currently have. And the conversation we recently went through for the ARs. So,
and it's 100, I mean, you'd have to.
The
I mean, taking
distances.
the clock issue. I don't know what the distance is.
There's clock, there's the
And
times,
it's
and
100, right, 100.
so we can
feet.
just, I can just go with the comparing that, so as a highlight, you're saying it's not decimals, it matches ours more to the distance times
right.
part of it.
right?
And then adding in, if we were to broaden, due to the fact that ours is only single family, but yet the areas that would like quiet are residential.
Right.
Not just single family.
Yes.
So that captures the environment that we have a little better to me.
I believe it does. So in talking to our enforcement folks, it does seem like part of the reason we can't obviously enforce now that amplification is because it's commercial entities in the normal course of their business. We're not receiving complaints, at least from the data that we have seen so far, from single family residents neighborhoods, right? Pertaining to amplified noise from a commercial entity downtown. And so because of that, there's not a mechanism currently within the ordinance to allow them to enforce for amplification of commercial entities. And to use David's example, those two businesses, there's no mechanism for them to enforce that because they're both businesses operating in the normal course of their business, right?
Yeah.
And so Clarke, for that example, it's not a single family neighborhood,
Yeah.
right? So that would not have registered as a reason.
Yeah.
You know, and just to throw in another, I live on Hill Street, very close to downtown, which is RM2. And, you know, I'll hear this incredibly loud noise from downtown. It's woken me up, bizarre time. And I know it's coming from downtown, but unless I go in my pajamas in my car, the dispatcher's going to say, well, where's the noise coming from?
Right.
I say, well, somewhere downtown. And their logical response is going to be, so you don't know where it's coming from. I just said, well, downtown, I can get in my pajamas and drive around downtown and figure it out, but, I think that's the dilemma that a lot of town residents, 5 points, et cetera, is, well, it's somewhere out there, it's waking me up.
Yeah.
Does anyone else hear this?
I will say too, I mean, just something to note, as you're looking at the Atlanta one also, they do the distance changes with regards, so it's a shorter distance when the noise is going into residential areas. And then it's a larger area when it's going into mixed use. So I think there was some deliberation and some real thought put into sort of.
But this wouldn't though address the plot and the bar next door because that's like 10.
That's,
So
yeah,
those-
we're gonna address that.
Those are
But-
commercial entities
But
near
they're so
mixed use.
close, they're so close that it
mean,
wouldn't
they're like
address it,
10
like it
feet
wouldn't fit
apart.
into the distance.
Oh, I see what you're saying.
So, but your neighborhood, you're saying it's RM?
So I'm too, actually.
RM2, so it would, right now, you can't complain because you're not single
Well, I can
family.
complain, but look at my zoning ordinance before I go outside and get mad.
Right, but then we could have someone, an officer could say, I can't do anything here, but this would address.
The last thing a homeowner.
Residential.
2 o'clock in the morning is a constitutional law lecture.
Right.
Yeah.
This expanding it to the other types of zoning would allow you to
Have more.
have more credence, like your officer wouldn't say, well, you're not in the right zone,
Well,
but it would.
right, and what's interesting as we look at our future land use, if we're gonna be changing zones too, we don't want to then change somebody to where they, oh, you're not single family anymore, even though you have a single family house and it's zoned differently. Now, you can't complain about the noise
Well,
complaints.
and also the other thing is you have with 60% of people renting and many of them not in single family zones, you're sort of like, well, if you're in a single family zone, your sleep is more important than someone who lives in an apartment complex. So I like that, not singling out those people who are living in single family zones for special protection from noise. I like that concept.
Yeah.
And I think it does go a little bit to addressing your like downtown or other places.
Right.
That idea, especially as we're looking into making denser commercial nodes or the possibility of that, I think that would make sense.
Mhm. And how about Smyrna? Who wants to talk
Oh.
about Smyrna? That one's a part of
Yeah,
the
what is that
decibel
one?
group, right?
What's the decibel?
Okay.
So,
Basically, Harrison from so many, it was, I printed the most comprehensive and the shortest, to give you
Yeah.
this is the range of how people deal with this.
Well,
issue.
and for me, I think that, to move this forward, as we learn more at the next meeting, obviously not moving anything forward today, but looking at what we can do with our distance way that we're doing it and maybe broaden it like the Atlanta one does. And because the decibel, if we want to start going that route, I think that would be like round two of the improvements that we could make versus it holding us up because of the equipment. It would have to be a budget item. It'd have to be researched as far as for the equipment training and that reality. So this is a lot of good stuff for sure. And thanks for leading through and giving us a highlight reel, literally, thanks.
Yes, thank you very much.
And then I guess, I don't know, do we need to have a component for mediation for commercial to commercial neighbors?
Well, they could call David.
That's right. we can go ahead.
David could put in the
Other
complaint
people
from his
decide.
house.
There you go.
Well, was there time to look into, when an entity is not doing their commercial primary zone? So my example was, you're a restaurant, but you're playing music. Your music's not your commercial thing. Was that able to be,
Yeah, we did kind of
or
look
was
at
that one of my memos I haven't read yet?
No, it wasn't.
I think
It
it's
wasn't. No memo on this yet.
maybe one comment. But I think what I'd say is, kind of what I was saying at the beginning of the meeting. You know, anything that this body recommends has to pass that test. But ultimately, it has to be a content neutral time, place, and manner restriction. And so I think the initial concern here, and I looked at some case law from the United States Supreme Court. There's a watershed case, the Town of Gilbert case. It kind of talks about content-based distinctions. And so I think the question I'd be asking y'all there is, so we're talking about distinguishing commercial entities based on one model offering sort of live music or performance that clearly involve expression, and another commercial entity that is also engaging in First Amendment speech by playing music. It's just not live music. And so distinguishing those, it kind of gets me concerned about we're looking at the content from those two businesses.
Not their business license, declared business. Like if the lawn care company decided that they were also gonna start blaring music to their power tools.
Yeah.
What you're saying is it's still,
I think we're still kind of getting.
it's
getting
still
to that
content, it's more
based.
content.
And the case law from the United States Supreme Court says that content-based laws are presumptively unconstitutional. And so then we're also, kind of behind the eight ball in that regard, trying to rebut that presumption while also passing the Statesboro test that talks about it has to be at least restricted means and leave open ample alternatives for communication. And so that would be the other thing too.
So that's where
Like can the restaurant, if we were to distinguish between restaurants and sort of live music venues, are we telling the restaurants that you cannot engage in the expression? You see what I mean there?
Right, because it's not your commercial entity, but it's part of your commercial model to come and not be able to hear the people you're talking to at the table.
Yeah.
It's just a model.
So for clarification, are we kind of feeling more like we want to focus first on trying to look at the Atlanta ordinance type model of seeing what it looks like when we start to model an approach where we're expanding it to mixed use zones? Or do we also simultaneously want to start looking at more of those Savannah, what do they call it again? I always forget this, noise sensitive areas?
I just, the noise sensitive areas are schools and, I mean, it seems like you're getting into, like, you're not going to be, that's not the issue that we're having. And you're also then making, I mean, if we know of anything, there are more incidents of people who are living in mixed-use residential neighborhoods. So it seems like that's going down along, addressing a problem that we're not having.
Okay.
But also the other one in the Savannah, it did have regulations of the sound equipment, that part of it. That part of it, I do want
Okay.
to learn more about in modern types of commercial entities, as well as how it looks when you are permitted.
Right.
In our example, it would be when you have a special event permit.
Okay.
You can do this, you're permitted this, but you're not permitted to do that. I'm picturing our new park and we're gonna have a stage up there. And I'm not sure that it would just be wide open for people to set up speakers and without a permit.
And so I
But that's-
already assumed that we're still going to invite the solicitor.
Yes, we will, especially if there's interest in exploring the decibel meter component further. We can invite the solicitor to the next meeting if that.
Would help us learn pros and cons of that, I think.
Okay.
It'd be useful in any,
Yeah.
if decibel or otherwise, any change to the
Yeah,
noise
yeah.
ordinance is gonna.
Yeah, I don't disagree. Okay. Well, is there any
Feel
other?
good? No, any good discussion?
Okay, well
Do
then,
you want to review?
that's what I was gonna ask, is if there's not any further committee discussion, I can review what I've written down as some takeaways for staff to bring back to the next meeting, and y'all just let me know if I'm missing anything. How's that? So first, we're gonna have our ACCPD look at the data again related to downtown to determine how many of our complaints were driven by commercial entities. We will still probably reach out to Savannah and Statesboro to learn more about the enforcement component for that decibel meter component, since we want to kind of focus on that.
Wait, go back to, so decibels, that was Sandy Springs and Smyrna.
Yeah.
Oh,
But I mean, I guess Savannah does use decibels too.
Mhm.
Statesboro might.
they do, because she mentioned the special event permit component. Okay. So we'll look into, we'll.
We'll reach out to
We'll
communities.
reach out to to find out more beyond what Harrison has already reached out to
Gotcha.
for decibel meters, to just tee up to that. We'll invite the solicitor's office to see if, our solicitor will come and speak to us about his thoughts related to this, or at least be able to share. Attorney's office, if you'll research a little bit more on potentially linking, to the special event permit for use, as pertains to amplified noise and particularly with decibel meters. And then Commissioner Wright had also asked for us to kind of look at from a legal perspective, if we could define a geographic area.
Okay, that's right.
Well, I mean, I'm kind of good with your saying the whole.
Okay.
Versus, areas that we, because then we might be leaving somebody out. I mean, we kind of did AR,
Right,
and so it's almost like the non-AR.
Everybody else, but
Yeah.
that was the donut, now we're in the middle. We're not exceptions after all, after we get all done.
But yeah, I think that I'm good with the way they had
Yeah.
already implied that it would be probably better.
The only thing I would add to that is whether or not there is, I mean, any way from a legal or like we're not, it doesn't sound like we're able to address the commercial to commercial interference. And, you know, can one commercial entity by its use of excessive noise interfere? Can we do anything that for one, that their excessive use of noise is interfering with another establishment's ability to run their business?
So one question I had in reading the Atlanta one, it seems to me, at least on glance, but I want the attorney's office who read it more in depth than me, that a commercial entity could complain if they are in that distance. If it was like, I think they're
That's right.
300 feet
Yeah.
beyond.
Right.
That's
But I'm talking about
Yeah.
like, if it's not
Oh, you mean
It
next
doesn't meet
door?
the
it's
distance.
next door.
I mean, I will,
I think from like a noise ordinance perspective, it's gonna be pretty hard to stop that.
Oh,
You know, there
really?
may be some sort of like civil nuisance, remedy available, because if you're talking about interfering with like a business model,
Right.
but I think.
Well, the question is, do we have anything outside of the noise ordinance that would apply to situations like that? Well, the one you just mentioned.
Yeah.
Yeah, civil nuisance, we can come back.
I mean, that would address the noise issue, but from a
For
different
neighbor.
angle.
Well, what if the distance, lower than the distance, 300 feet, lower than lower than that is a decibel thing.
Oh, is it?
You know what I mean? If you're in that shorter distance, what would be a decibel reading that would clearly say, yeah, that is too loud?
we can look at that,
Yeah.
some sort of hybrid model like that.
Yeah.
Yeah,
And I will say, and again, not recommending it necessarily, but, that more draconian for better, like, for lack of a better word, Savannah and Statesboro, I think probably would address that, because it talks about how the noise has to be contained within the premises of the, but that's, that's.
So we would
that's
look
a
at
lot,
that,
but
yeah.
Yes. That's a
without a
lot.
permit, because there were like, if you had a festival,
Right.
that was.
Yeah.
allowed.
But I'm thinking about the Paloma too.
Right.
Issue.
Or potentially, a new food park next to Morton Theater, you know, they're gonna certainly have an active food truck area right next to where Fort Morton, probably not the sound food theaters, might be having a performance at the same time.
Right, so it's hard to distinguish between outdoor food or an outdoor seating area for Paloma, right? So those are just things to think about, but the hybrid model, yeah, we can look into that, see if anybody does have.
Because that could be a refinement upon learning more about the equipment and also listening from the solicitor. Of that,
Yeah.
because, I mean, Denny Tower, we've heard complaints from Denny Tower too,
Mhm.
as far as it being our longest, I would say, family area.
Okay, anything else?
No,
Do we
that
need to
sounds
wait
great.
till December for all this stuff to be put together?
Well, and speaking of,
You would not get an objection.
Do you have on your calendar that we already have something that we're invited to, the, Game Changers? But we have some at the school district from 1 to 3 on that the Thursday, the 6th.
Oh.
Does anybody else have that?
well, I have seen in my personal schedule that I will be out of town.
Well,
from
this
the
is
5th through
looking
the 8th.
good. Okay,
So-
let's go to December.
So I will not be here on November 6th.
And we might need that much time to get the solicitor's schedule aligned with this.
So are we looking at December 4th?
Yeah, we're looking at December 4th.
Okay.
Is that okay
Back
with
first
everyone?
first?
Oviedo?
Yeah,
No complaint from staff.
if I don't show, I won't be here, but, no, right? Right now, it's fine. It works.
Feels like forever.
And then,
And that'll be the, parade light. That's the parade lights night too.
oh, is it
If just,
on the 4th?
just-
Well, it'll be a big day. I mean, and you may
It
just
should
start
not be
thinking
different.
ahead from
Okay.
for January. I don't want to even think about this. But yeah, we're not gonna have a meeting on January 1st.
Oh, no. we won't.
Right, that was the day off anyway, right? So,
Yeah.
that would,
be
if we
the
had
8th.
one in January, it would be on the 8th.
Correct, yeah.
Okay.
Let me find that November LRC.
Okay.
All right, motion to adjourn.
Second.
All in favor?
Aye. Aye.
Thank you, everyone.